सेव किया था ना?
मैं सिर्फ इसलिए गया था क्योंकि उसने मुझे कॉल किया, that's it. But listen तो.
Save it for someone else.
जिंदगी में सेव करना जरूरी है, मगर जब बात पैसों की हो, सिर्फ सेविंग से काम नहीं चलेगा। इक्विटी म्यूचुअल फंड्स में इन्वेस्ट कीजिए और अपने सेविंग्स को आगे बढ़ने का मौका दीजिए।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
Bombay High Court has given us a very important order. It's an order written by Justice Bharati Dangre. So thank you very much, Justice Dangre. It's a very important order because what it does is it completely opens up the debate on the age of consent as it applies to Indian women. The current law says that a woman until she is 18 cannot be seen to have given her consent for a sexual relationship with anybody, and she can come to court and say that no, I had given my consent, I consent to this is consensual, but this is not considered to be consent under the laws. Now that's been a debate that's going on for quite some time. There are many judgments from high courts, there are observations by the Supreme Court, there is observation also by the current CJI. I will tell you more about that. But right now, Justice Dangre has opened up this case, opened up the debate with her order in the case of an unfortunate, a deeply unfortunate man, mark his name. His name is Ashiq Ramzan Ansari. Ashiq Ramzan Ansari was 25 in 2016 when the story begins. In 2016, say 1st of February 2016, he quote unquote eloped, disappeared, went away with a young woman who was 17 and a half years of age. Her brother went to the police and said that my sister was missing. Now police started searching for them and soon enough the police found them. So next month in March of 2016 they were tracked in Gujarat in Anand, the city of Anand. So 18th of March they were found in the city of Anand. That is when they were brought to Bombay. They were brought to Bombay and a case of rape and also under POCSO Act. POCSO is Protection of Children from Sexual Offences Act. A case under both of these and other tough IPC laws was filed against the man, against Ashiq Ramzan Ansari, who was then charged with having raped the woman who had gone with her full consent with him. Now see how this worked out. The trial court said that look, she may say that she gave consent. The woman stood up in the court. She was very forthright. She did not waver even for a moment. She said she knew what she was doing. She said she was immatriculate. She understood what she was doing. She had no hesitation. Even now she wasn't changing her mind. But in spite of all that, the trial court said that look, none of this works because at a time when it happened, you were not 18. You were 17 and a half years old. And this man then, Ashiq Ramzan Ansari, was given a 10-year sentence. He was convicted for rape and under POCSO Act, very tough act. That's the act from which Delhi police has tried so hard to save Brij Bhushan Sharan Singh, the wrestling federation chief, because they know how tough that act is. So while they have filed charges against him under other provisions of IPC for sexual harassment, they are still trying to protect him from POCSO Act. So this man, Ashiq Ramzan Ansari, was also charged and convicted under POCSO Act as well, given 10 years of jail. Now you might ask me a very simple question. You might ask me, oh, if the woman said that this was all consensual, the man of course is saying it's consensual, he's not complaining, and in any case it's not for him to complain. So how did the police take cognizance of the case? So who's the complainant in this case? And how does the cause for action arise? So once again, very interesting. As the couple were brought back from Gujarat, as provided under the law, the woman was taken for medical examination. In the medical examination, it turned out that she was pregnant already. Now, because she was pregnant, it was established that she'd been having sexual relationship with this person and she never denied it. She only said this is consensual. And while she said that, again, the laws, the set of laws being what they are, it was still considered to be rape As it turned out, a few days later, that is on 22nd of March 2016, she also went through medical termination of pregnancy. Now, if you see the trial court's order, there are several ironies in it. The first irony is that the woman saying, look, this is consensual, I've gone away with him out of my own volition. So where is the problem? Second, she is not the complainant. Third, even her brother is not the complainant because this is a criminal case. She is not saying that she was raped. It is because she tested as being pregnant in her medical examination that the cause of action has arisen. And once again, if you see the court's order convicting Ashik Ramzan Ansari, that is the ultimate irony because it convicts him of rape, it convicts him under POCSO Act for sexual offense, serious sexual offense against a child, against a non-adult, a child by definition. At the same time, it acquits him on the charge of kidnapping. Why? Because on kidnapping, they say the woman said she went of her own volition. So he did not kidnap her. Now, look at this irony that he raped her, he committed awful offenses on her as a child under the Child Protection Act, but he had not kidnapped her because there she had given her consent. So in one case, going with him, her consent is admissible. Having sex with him, her consent is not admissible. And I know what's coming in the minds of many of you or many of us. This is natural these days. That's the way our public debate is. A lot of people will be thinking, oh, this is one more case of love jihad. So let me also not leave any confusion there. In this case, in this particular case, the woman also happens to be a Muslim as the man is. So there is no such thing like that. It is not the same old stereotype story that you see on a TV channel all the time, people screaming about it, of an older Muslim male, Bella Puslake, or manipulating a young underaged woman of another faith or Hindu faith and taking her away. It's not like that. The man and the woman both are Muslims in this case. So this man had been incarcerated. So think again, a man at 25 goes away with a woman at 17 and a half, is found by police, is charged with raping her when she is not accusing him of raping her at all. He was given a 10-year sentence. This is now 2023. He's filed his appeal in the High Court. It is now 7 years later that the High Court has acquitted him. Now, a lot of his life is lost. A lot of his life is lost. A lot of the woman's life is lost. And she said multiple times that they've been in love. They were in love. She loved him. In fact, that is something that the High Court order notices, that she's been forthright in her testimony. But in spite of that, these two suffered because of the way our law is structured right now. So first of all, I will go into some detail of the court's order, and if you want to read more about it, see the story by my colleague Apurva Mandhani, of which I am sharing a link with you with the description of this video. So please see that. So she says, the judge says, and I quote from her, the age of consent of 18 years in criminalizing consensual adolescence and teenage relationship. That is what she's questioning, and she's saying that is something that Parliament should now talk about. Again, the judge says, and I quote again from the judge, she says, criminalization of romantic relationships has overburdened the criminal justice system by consuming significant time of judiciary, police, and the child protection system. And she says that a huge chunk, this is a quote unquote from the order, that a huge chunk of POCSO cases in the courts now are about romantic relationships. So what happens? A 17, 18-year-old, and she makes a reference to hormones a little bit later. 17, 18-year-olds have relationships and the parents or somebody gets aggravated, or people out of fear disappear, they elope, they go away from home, somebody gets pregnant, and that leads to police action. That is what is clogging up the court system. And she also says that in many of these cases, the woman herself does not accuse the other person of rape in the courts, and the woman does not cooperate with the prosecution side because she is not a prosecutrix. This has her consent, and that is how a lot of these cases fall. But at the same time, they clog the court. except a problem arises. A lot of these cases fall because the woman turns hostile, as the law calls it, or as prosecution calls it, but it gets complicated if the woman is already pregnant, as was the case in this particular one. And the judge also goes on to say, and I quote, the POCSO Act cannot stop the natural feelings towards the opposite sex, particularly in the age which accounts for biological and physiological changes. This has to be a very progressive and a very forward-looking and a very modern judge. Is at a time when everybody is just virtue signaling or being patriarchal or trying to play parent, uncle, auntie, stuff like that. This is a very modern, forward-looking judge who knows the realities of a young person's life these days. And then she goes on to say that, look, today in the current legal system, if a minor boy and minor girl have a consensual sexual relationship, a minor boy, minor girl, and I quote from her, quote, who were in the grip of their hormones and biological changes, unquote. I told you she refers to hormones in the judgment, hormones and biological changes. What will happen? The law will work against the best interest of the child. And she says there is a gray area. This has definitely resulted in criminalizing consensual adolescence, teenage relationships, and Parliament should look into it. These are very important observations. As we go deeper into this discussion, I will also tell you a little bit about where these laws came from and when. And with the description of this video, you will also find several links to stories we have done that our team has done on similar subjects, because there are many observations by other high courts. Madras is one, Karnataka is another, Punjab and Haryana, several high courts saying that, look, this is an unfair law. You cannot prosecute people, you cannot punish people if this was a consensual sexual relationship. And multiple high courts have also recommended to the government to do something about this law. Last week, for example, just before the Bombay High Court order, Madras High Court also gave a similar order. That was about a minor boy and minor girl. In fact, Madras High Court also gave directions to Tamil Nadu police to collect all such cases of consensual sex between a minor boy and a minor girl, where the minor boy was charged with rape and under the POCSO Act. However, the greatest clarity on this issue has come from Justice Bharati Dangre's order. She says, for example, talking about sexual autonomy, she makes a reference to sexual autonomy, and she says, and I quote again, that sexual autonomy code encompasses both the right to engage in wanted sexual activity and the right to be protected from unwanted sexual aggression. So, the message being, don't confuse one with the other, or don't conflate one with the other. And then she goes on to say, and I quote again, protection should also enable young people to extend their boundaries, exercise choices, and engage in necessary risk-taking, though not exposing them to inappropriate response and danger. So once again, make a distinction between what is consensual, what is done out of willingness, out of curiosity, out of whatever might be driving somebody's heart, mind, emotion, decisions, whatever, and what is criminal and what is force. So make a clear distinction between the two. And she says, she gives an illustration that, look, if a boy at the age of 20 has consensual sex with a woman who's 17 years and 364 days old, this will still be called rape. The boy will be exposed to the full force of the rape law. And she says again, in consensual relationships between teenagers, and I quote again, in consensual relationships between teenagers who fell for attraction of the opposite sex and enter into a sexual relationship out of impulsiveness, only one has to take the consequences. That's the boy. Only one has to take the consequences on being charged with rape, although the other also indulged in the same act. So she's also telling you that this law is also unfair on the basis of gender. It's unfair towards the male, towards the boy. And then she says, look, we have to be cognizant, again I quote, we have to be cognizant of happenings around the world, and I quote again, and then she gives examples of the debate in many countries. In many of the countries, she points out, for example, that the age of consent is 16. 18 is too late. And frankly, if you look at it purely in terms of Indian women. What has Indian law done? Indian law has said that an Indian woman cannot give consent for sex until she is of a legally marriageable age. So this does not apply to men. Men can marry at 21, that is a marriageable age, but they can give consent earlier, but not the woman. So there is also an element of patriarchy there, because it limits a woman's agency or a woman's ability to give consent to have sex until she is of the legally marriageable age. These are areas of debate. She also notes, as I had mentioned while telling you the story of Ashik Ramjan Ansari and his partner, she says that the girl in this case, and I quote, was clear in her version and about her expectation from her own life, fully aware and ready for taking the consequences. Now, you know what? There is that old saying, Miyan Biwi Razi to kya karega Qazi, right? In this case, and in many such cases, the man and the woman are both okay. In this case, I know because they are Muslims, you might say that I am using a metaphor which may or may not apply literally to this case. So, Miyan Biwi Razi to kya karega Qazi. Maybe in this case, one complexity lies in the fact that a Qazi wasn't involved. So, while this woman came to the court and said, look, I'm a Muslim. I can, under my personal law, Muslim personal law, I can marry before the age of 18. In fact, I can marry after the age of 15. So, how is this illegal? How can I not give consent? But in this case, apparently, because there was no nikah nama, a Qazi was not formally involved, so it was not seen as marriage. The trial court also did not go into the merits of the claim of whether this was a marriage or not, because in this case, that formalization had not taken place. Now, if you look around yourself, do you really believe that our boys and girls who are today going to school, senior school, early college, between the age of 15, 16, 17, 18, they remain completely quote-unquote chaste in a Victorian sense until the woman passes the age of 18 and the man passes the age of 18? Obviously, it's not happening like that. People are exploring sexuality much before that. Now, you might say, Zamana kharab hai, things are so bad, there are so many influences. You can rave and rant about anything. I'm giving you some opinion here. But at the same time, you can't play King Canute and turn back the tide of time or the tide of hormones. These are realities, and that is why it is necessary to reform this law, because this is leading to over criminalization of sex. The idea was to protect children from sexual violence. This is now punishing them for something that they are doing consensually. So this is limiting their options. Now, in India, we have gone backwards with this law. From 1940 to 2012, the age of consent in India was 16. 2012, POCSO Act was amended and the age was raised to 18. Now, I know that immediately, I had also thought immediately that this must have happened because of the Nirbhaya case and the activism after that. But Apurva Mandhani tells me that this had happened earlier. In fact, Justice J.S. Verma, who headed the committee looking to modernize laws to protect women from rape and sexual crimes, that committee recommended that this age of consent should be taken down to 16. The committee in fact made a reference to Article 34 of the UN Convention on Rights of the Child, which said that look, law should be made to protect children from sexual assault. Law should not be made to criminalize consensual sex. But in that mood, nobody listened to them. And in any case, we tend to be conservative. Older people sit in parliament, older people tend to be conservative. And that's how this law came into being. So 1940 to 2012, the age of consent was 16. In 2013, Parliament amended the law and made it 18. So while the age of consent was raised to 18, there was one existing exemption in the rape law in section of IPC which defines rape. That was exception 2 of section 375. That said, a man married to a woman who may be below 18 years of age, but if she is above 15, even if she is below 18, a man having sex with her is not committing a sexual offense, right? So that was considered to be legal sexual activity. That was challenged by an NGO. It was challenged by an NGO called Independent Thought, and in the 2017 judgment, a significant judgment, Supreme Court of India read down this law. They read down this law and they took away this exemption. Now they took away this exemption in marriage. So say person A aged 25, person B aged 16 got married. Earlier, sex between them was considered consensual and legal. The Supreme Court read this down and said no, a woman in this case also has to be 18, that this exemption is not allowed in the rape law. But that also left one complexity behind. That is, if in a community's own personal law, a woman is allowed to get married before the age of 18, which precisely is the case with the Muslim personal law. That is the larger debate right now which is going on about uniform civil code, about Muslim personal law, age of marriage. To that also is tied the question of the age of consent. In the middle of all this, NCPCR, which is the National Commission for Protection of Child Rights, they've also gone to Supreme Court and they've also challenged this idea, because they've said, look, you can't say that POCSO does not apply to consensual sex between a man and a woman below the age of 18 just because she happens to be a Muslim, even if she's married to the other guy, because POCSO Act, they say, is a secular act, right? It's a secular act, so that overrides every faith's personal laws. Now, if that overrides the personal laws of those faiths or tribal communities in India where people get married earlier, particularly women get married much earlier, that causes an enormous amount of legal complexity and clutters the criminal system entirely. That's why these debates which are taking place right now are very, very, very important, and that's the reason the order that Justice Bharati Dangre has given from Bombay High Court is so significant. And in this very cluttered mix, there is yet another complexity in the name of Prohibition of Child Marriage Act. That actually makes a man liable to a two-year jail sentence for marrying a minor woman. Once again, for many communities, the definition of minor and major adult is different, and that is why this debate over uniform civil code is so fascinating and so significant.